Welcome to this new video conference in which we will reflect on the practical implications of the new reduction in the maximum weekly working hours starting from July 15th, 2024, and its implications also in terms of occupational safety and health. My name is German Plaza. I am a lawyer from the Javeriana University, a university professor, legal consultant, author of several books related to these topics, and a regular speaker on the subject. Let's then begin our meeting. Remember that additional information on all these matters can be obtained through any of the means written on the screen. There you can register your details and receive updated information on all these matters. Let's get into the subject. Law 2101 of the year 2021 mandates the reduction of the maximum weekly working hours from 48 hours to 42 hours a week over a specified period, which ends in the year 2026. Thus, by July 15, 2023, the working hours should have decreased from 48 to 47 hours in July 2024, from 47 to 46 in July 2025, from 46 to 44, and in July 2026, from 44 to 42. That is basically the schedule for the reduction of the maximum working hours proposed by Law 2101 of the year 2021. This same law establishes that the reduction in working hours cannot affect workers' salaries. This entire regulation exempts people working in the surveillance sector. They have a special regulation that is not governed by this law 2101. The Ministry of Labor issued a unified concept on how to interpret some aspects of this law, specifically regarding how to calculate the value of each worker's hourly wage. As the working hours decreased, the ministry made the following table. Look at this. To establish the value of the hourly wage, for example, in July 2023, which was the year when the weekly working hours were reduced for the first time, what the ministry said is, take the person's monthly salary and distribute it among 235 hours, which will be the number of hours per month that the person will work. Remember that before this law 2101 came into effect, the maximum weekly working hours were 240. With a reduction of 1 hour per week, it decreased to 235. Starting from July 15th, 2024, what needs to be done is to take the value of the worker's monthly salary and divide it by 230 hours, which will be the number of monthly hours the worker will work due to the reduction of the maximum weekly working hours to 46 hours. Starting from July 2025, what will need to be done is to take the worker's salary and divide it by 220 hours, which will be the number of monthly working hours due to the reduction in working hours that will be applied that year. And in 2026, the monthly salary will be divided by 210 hours, which will be the number of hours the person will work per month due to the reduction in working hours, which by that year will already be 42 hours per week. Notice then how we decrease from 140 hours until 2020, until July 14th, 2022, and there we start to decrease to 235. Then, this year, 2014, to 230 hours. The following year, to 220. And then, to 210. The value of the hour then, in practice, will increase because it is the same salary for fewer hours worked. In practice, the value of the hour increases, and that basic hourly rate will be used to calculate the value of overtime, night shifts, and Sundays. That's what the Ministry of Labor says. Now, it's not just the reduction of the workday. It's not just the economic impact of the reduction of the workday. This has other implications. For example, if the maximum workday decreases and the company needs to work beyond that time, well, overtime will start to accrue more quickly. The permit for overtime hours must be processed with all the legal requirements that the ministry has recently demanded, both in labor matters and in health and safety. Uh, there's the economic issue, of course. But there's also a matter of workplace health and safety. Recently, the Supreme Court of Justice issued a ruling, the one here on the screen is ruling number 809 of the year 2024. What happened in this ruling? An employer wins a contract needed to carry out a project with an entity. That employer hires some workers to operate a machine. The employer makes a work contract with those workers, assigns them a maximum legal work schedule. The employer says that he provides them with training, gives them the training, familiarizes them with the machine. Due to service needs, he makes them work more hours than the legal maximum. And during one of those shifts that exceeded the legal maximum, the worker has an accident while operating the machine and dies. There was a work accident, the ARL pays the survivor's pension, but a series of investigations begin. And for example, the Attorney General's office, or rather, the family claims that the accident was the company's fault because it did not train the worker. The Attorney General's office also says that fatigue and lack of training could have contributed to the fatal outcome of the accident. And finally, the Supreme Court of Justice, after resolving a process initiated by the family, condemns the company, the employer, to pay compensation for civil liability because the court considered that the employer did not adequately identify the risk generated by long work shifts, fatigue, the psychosocial risk, and imprudently exposed the worker to those risks, which was decisive for the occurrence of the accident, and because of that they condemned the employer to pay a substantial compensation for civil liability to the family. Look quickly at what happened in this case. So, the worker is hired with a maximum work schedule written within the law. A remuneration was agreed upon for him to work operating a machine. The man has an accident, dies, as I told you. The Attorney General's office says that that personnel in charge of operating the machines did not have safety protocols. There was fatigue. There was no fluid communication between the workers because the communication radios were not working. The plaintiffs say, the family says that all this demonstrates the employer's negligence, why they made them work shifts that exceeded the legal maximum, causing fatigue, exhaustion, which were the causes of the accident. The employer says that none of that is true, that he trained the people, that the fault was rather the workers for having violated the machine handling protocols. The case then reaches the courts, and it is established that it is said that the employer must identify occupational risks in a timely and prudent manner. Must implement the relevant prevention measures to prevent those risks from affecting the worker's health. In case of an accident, the employer must demonstrate that they acted reasonably and diligently to prevent the incident. The burden of proof that the necessary measures were taken lies with the employer. The employer has the duty to identify risks and implement measures to prevent the worker from having an accident. These are the considerations made by the Supreme Court in its ruling. The worker was experiencing fatigue due to the workload or the duration of the shift performed. It was a routine, monotonous activity. The worker was inherently using a dangerous piece of equipment. And the judges say that in the investigation documents, it is indicated that those psychosocial risk conditions were the causes of the accident, the fatigue, the non-compliance with safety protocols, the lack of prevention of psychosocial risk by the employer, and in general, the lack of implementation of safety measures. So, be careful. This issue of reducing the workday goes far beyond lowering from 48 to 47, now from 47 to 46, next year to 44, and then to 42. It's about overtime, and also about workplace safety and health. Be careful about exceeding maximum work hours. It's important to identify how this can affect the worker's health, as stated by the court. Necessary measures must be implemented to prevent these identified risks from affecting workers' health. All of this is part of the comprehensive prevention of psychosocial risk. These are the topics I wanted to share with you in today's video conference. I hope the information has been useful to you. Remember that you can leave your comments on this video conference using the QR code that appears on your screens. It will greatly help us with our internal improvement plans and provide additional information on all these topics through any of the means written on the screen. Access is completely free. Thank you all very much. I wish you a happy rest of the day. Until next time, thank you.